There will be a limited speaking time for attendees, but we'll see how we can accommodate everyone. If you have anything you'd like to send in, use the bylaw, kingbylaw@rjburnside.com, and there'll be a matrix of questions and comments and responses to the public consultation, as well as the reach out we've done to various stakeholder groups such as conservation authorities in the region and things like that. All documents will be viewable on the King website. That's where all the documents that we talk about today are, where this presentation will be posted, and the matrix of all the questions and our responses to those questions. So the bylaw is called the Site Alteration and Movement of Fill Bylaw. And then the term movement of fill, it focuses on moving fill from point A to point B, which seems to create a lot of controversy. So it's designed to manage both site alteration, cutting and filling, as well as transportation. And usually the focus on movement of fill is the importation of fill from another site. This replaces the current King bylaw and the various amendments. It's old and out of date, and it does not align with recent changes in regulations, provincial policy, and legal precedent. This bylaw addresses changes to the Municipal Act in 2020. And one of the things in there is it recognized the need for reuse and recycling of excess soil. Ontario Regulation 406-19 comes into effect in January of this year. It came into effect in January of this year, and this bylaw is aligned with that. Changes the construction industry and increased expectations of environmental stewardship. This bylaw has teeth. It is updated legal language to fine and prosecute illegal activities. We had prosecuting legal counsel assist the municipal legal counsel in preparing the wording for this bylaw. Any activity that alters the grade or topography of land is deemed a site alteration. Any non-natural transfer of fill, which includes soil or peat or any material, from one property to another, any distance within the township is deemed a movement of fill, and that is on a property or off property. And that excludes fill that's transported through the township, and is always contained within the transport vessel. So material that's moving through the township on trucks, this does not apply. So the purpose of site alterations, sometimes people suggest that we should just ban them outright, but there's many good reasons why people may want to do site alterations: for improved drainage, creation of noise berms, stabilization of slopes, development of lands, buildings, employment activities, recreation, creating ski hills, flattening out portions of properties for horse tracks or paddocks, enhancement of natural features such as ponds and wetlands. So the ministry and the Conservation Authority is only too glad to see people create artificial wetlands and enhance wetlands in their areas. Improved use of agricultural lands. Sometimes agricultural lands have been altered over the years for different purposes, and restoring them back to and put them back into use. This is often seen with aggregate pits and borrow pits, where they are filled back to surface, and the surface topography restored, topsoil placed, and the land put back into use for agricultural purposes. It is important for all stakeholders involved with these bylaws to consider the rights of landowners to develop their properties, enhance uses while protecting the environment and limiting the impacts to neighbors. So rather than an outright prohibition on any type of site alterations, we tried to develop a bylaw that offers a lot of control and consideration for the environment and for neighbors, but also gives landowners the right to develop their properties. The bylaw and supporting documentation, which includes a guidelines manual, are aligned with the needs of the township and all of its residents. The township has to balance these needs. Non-negotiable are environmental stewardship, the long-term protection of the environment, and heritage features. Heritage features could even include topography, such as the Oak Ridges Moraine, where it's damaging to the topography of the moraine and the heritage features of the moraine by trying to flatten it out to make it a pool table. Recognition of provincial policy for beneficial reuse. As I mentioned previously, there was a change to provincial policy statement in the spring of 2020 that encouraged reuse and recycling of excess soil. The balance of needs of residents who have environmental concerns and are concerned about liabilities and nuisance impacts, such as truck traffic. Businesses are looking for economics, development, developing their properties and jobs. Landowners often want property enhancements and the use of excess soil to restore aggregate pits, put up sound berms, manage their farmlands. And part of the balance of needs is to do this and administer these bylaws and the enforcement at no cost to the taxpayers, to follow a user pay model. And the bylaw aligns with other agencies. So we've reached out to the region and conservation authorities and the Ministry of Environment. And the bylaw allows site alterations and fillings for the benefit of landowners and the township, while maintaining a high level of environmental protection. It's aligned with the township strategic plan and other agencies with jurisdiction, conservation authorities, MNRF, who looks after aggregates and trees, and the Ministry of Environment, Conservation and Parks, and specifically alignment with the new OREG 406-19, the excess fill regulation. It's aligned with OMAFRA, balanced not to encroach on the rights of farmers. So farmers have certain rights to manage their property and manage their farms, and this bylaw does not encroach on those rights and tries to align with farmers on the use of their property, but is very stringent in protecting the damage to farmland and damage to topsoil and crops. So the bylaw would not necessarily allow people to come in and just fill right on top of good agricultural land. That's not the purpose of the bylaw. Ontario Regulation 406-19 came out in December 2019. Having it come into force was postponed once until January 2021, and it is in force now. It's the on-site and excess soil management regulation. The technical items adopted by reference in this regulation were the rules for soil management and excess soil quality standards. So this is a set of rules and tables that dictate what quality of soil can be placed in what type of location. So if you're placing soil on a property that's an industrial commercial property, your quality of soil can be different than if you're placing soil on farmland or parkland or residential land. There's a reuse assessment tool. It's a very shortened version of a risk assessment tool that can be used to develop property-specific standards. This regulation has really assisted municipalities in that it provides a prescriptive process at a provincial level that must be followed when managing excess soil. The regulation also included amendments to the brownfields regulation, the record of site condition, and amendments to the waste regulations, OREG 347, so that the terminology in all the regulations now aligns. And there were also consequential amendments to the registration of waste management systems. These are for treatment of soil and soil management sites. The purpose of this regulation, and why I'm going into it, is because it's one of the reasons that the bylaw was rewritten, and we were able to take a lot of detail out of the bylaw by simply referencing this regulation. This regulation has a lot of detail in it. It is a provincial regulation, so everybody in the province must follow it, and it provides a good backbone of assistance to municipalities who are dealing with excess fill and site alteration. The 406-19 provides clear rules for the beneficial reuse of excess soil. It designates when soil is a waste and provides criteria that removes this designation, such as if you take soil that is a waste and you place it on a site that is has soil quality requirements that allow that soil to go there, then it's not a waste. It's being used for beneficial purposes. It specifies when waste approvals are needed and when exemptions are provided. So sometimes if you're managing soils and you have hydrocarbon contaminated soil and you're treating it on a property, you would need a waste approval. If you're just letting it naturally dry, such as liquid soil that has been excavated from a pond, it doesn't need a waste approval. It sets out minimum requirements to ensure information, such as the characterization of the soil in the first place, is available to determine the reuse of this soil and to track the movements of the soil. So it assesses the soil at the source, it tracks its movements, and assesses the places where this soil can be reused in an acceptable fashion. This is all under OREG 40619. We don't have to write it into municipal bylaws anymore. This bylaw integrates with the provincial regulation and enhances township control and management of site alteration and the movement of fill. The bylaw details. It applies to all site alterations and movement of fill activities within the township, regardless of size. The only exemption is for higher regulatory authority, such as York Region, Province of Ontario, and Government of Canada projects. And any activities except minor site alterations require a permit. We'll get into the size of the site alterations that don't need a permit shortly. And even where a permit is not required, all the environmental and property protection requirements of the bylaw still apply. So that means even if you don't need a permit, you must only import fill of a quality that's suitable for your property. You can't change the drainage on your property to disturb your neighbors. You can't create a lot of dust or other nuisance that may affect your neighbors or the environment. So even if you don't need a permit because of what you're doing falls below the threshold for a permit, you still have to follow all the necessary environmental and control requirements. So this may have some applicability in the case of small civil disagreements. And the question was, should the township get involved in small civil disagreements where one neighbor has changed his grading a little bit and now runoff is affecting his neighbor? But the powers of the bylaw are discretionary. So the township can decide what action it may or may not want to take on a case-by-case basis. So if there's a small issue and it can be handled easily between neighbors or in the courts, maybe bylaw officers can attend and try and get people to settle it. But it's up to the municipality how much they're going to get involved. The municipality does not want to be drawn into small neighbor squabbles over small items. Bylaw section. So the bylaw is laid out in a variety of steps and sections. It starts with a title and the regulatory authority for the bylaw. So there are parts in the bylaw that reference the Municipal Act that demonstrate the authority of the township to construct these various components of the bylaw. So not everything in the Municipal Act is put in the bylaw, but the key parts of the Municipal Act that apply to this are put in the bylaw for reference. There's an interpretation and administration section to the bylaw at the beginning, and definitions. Definitions are very important. The words and terms used in the definitions are aligned with other relevant legislation. A significant list of definitions has been included to match the Ministry of Environment's regulations, which focus on soil rather than fill, which is more inclusive. Like fill can include peat, it can include rock, it can include clean concrete, and it also includes soil as defined by the ministry. So the definition sometimes can seem a little awkward, and but the definitions have been chosen to align with other regulations and terms that are recognized legally. So we may have an awkward definition for something, but it's something that the lawyers can use when they are doing prosecution because it's a known and legally accepted definition, even if it is awkward. So rather than have the township come up with all its own definitions, where possible, we create definitions that are aligned with existing legal language. There are prohibitions in the bylaw of things you can't do. There are exemptions from the bylaw. As mentioned previously, this is usually in deference to a higher regulatory authority. We're not going to dictate to the government of Canada what they can and cannot do. There's requirements for the issuance of a permit, the steps that must be followed, and the application components that must be provided in order to get a permit. There's even exemptions and waivings of permits and in certain cases, but it does not exempt compliance with the environmental protection and impact to neighbors components of the bylaw. So even when you're waived, those components still apply. There's a section on the abandonment, expiry, renewal, transfer, revocation, amendment, and closure of permits, the various actions and various situations for various permits. Enforcement, the roles and authority. We'll get into that later. That's where the teeth is in this bylaw. The orders that could be issued by bylaw, work done by the township. We've put this section in so that the township may take on work to comply with an order, and the owner is responsible for the costs. This is the case where someone has not complied with an order. There's an ongoing concern for the environment, or there's a requirement to protect neighbors that certain actions be done on property. This bylaw allows the township to go in and conduct that work and put the costs on the owner. Penalties and offenses. So there's fines and offensive penalties for any offenses in not having a permit, violating the conditions of a permit, and not following an order. There's an appeal section. This is an appeal allows a landowner that is issued an order by an officer or the director to come back to the table and talk to the town and work out a reasonable solution. The idea for this is to allow a specific opportunity to reduce the tensions and have a discussion in more of a formal manner within the bylaw and reduce litigation. Sometimes things can be handled without getting legal counsel involved and spending a lot of time and money and getting your back up. So an appeal provision allows that sort of second look and breathing space. Transition provision to this is for closing the old bylaw and enacting the new bylaw and effective dates when signed into force. The idea is that we go to public consultation over the next month, and at the end of that, revise the documents, revise the bylaw based on what's been provided, and then take it to council for approval. Definitions and wording. We mentioned this earlier, that that's often subject to debate depending on the personal expertise and perspective of people. So if you're an expert in soil, you might have a different perspective on what the wording of soil is. If you are a contractor, you may have a different wording. So these definitions can be critical when in litigation. So whenever possible, we've used definitions that are derived from provincial definitions and are known in the and already have legal recognition. So the definitions come from the Municipal Act, OREG 40619, OREG 15304, the brownfields, and 347, the waste management regulations. So some of the definitions may be awkwardly worded, but they are well known, and everyone throughout the province, both business and legal counsel, understand what they mean. We have size thresholds in this bylaw for the various site alterations. A minor site alteration is one that is excluded from needing a permit, providing you meet certain conditions. And a minor site alteration could mean different things on different sizes of property. On a small townhome property, it could mean one thing, and on a 100-acre farm, it could mean another. So the actual amount of site alteration that you're allowed is based on a small formula that considers the size of your property. And it is up to a maximum of 200 cubic meters that would be minor, no matter how big your property is. That's the maximum. A small site alteration is anything up to 1,000 cubic meters, and that would be roughly 100 truckloads, 100 tractor truckloads in any 12-month period. Above that, you have large site alterations, and large site alterations have specific additional requirements, permitting requirements, posting of securities and things like that, that the town would need in bigger situations that have more ability to cause an environmental impact or an impact to neighbors. The definition of fill, I won't go through this in detail, but we provide a clear definition of fill so that the users of the bylaw understand what it means, and bylaw can quickly go out and define what people are moving and what terms apply to what fill they're using. So sometimes fill can be compost. There's even could be rock, could be sod, and it could be soil. OREG 40619 is a soil regulation and doesn't really address some of these other items. We put these definitions in so that they're clear in the bylaw because it is a movement of fill bylaw. Topsoil is defined, and conservation of topsoil, of course, is very important in King. There are a lot of agricultural properties. A minor site alteration, as I mentioned previously, is based on the size of your property and the number of hectares of your property, and what amount may be allowed if you have a small property and what amount you may be allowed if you have a large property, up to a maximum of 200 cubic meters. The size has been based on what is to keep things like swimming pools and small amounts of garden work on properties under this threshold. So you're not requiring the swimming pool contractors to get a site alteration permit for simply excavating a pool permit. That's why the volumes have been set where they are for not needing a permit. Volume in cubic meters. What does a cubic meter mean? Well, here are some examples for people that aren't familiar with the term cubic meters. A washer and dryer put together, a large two-seat sofa. That is a cubic meter in volume, and that will give you an idea of what we're talking about. Small and large site alterations. So we've defined what a small site alteration is: less than 1,000 cubic meters, less than 100 triaxle truckloads. And a large site alteration is anything over a small, and that does not meet the definition of a minor site alteration or a small site alteration. So sometimes people may want to store material on their property and it's not really an alteration. That would fall into this category. It's designed to be more of a catch-all. If you're doing large site alterations, you will be required to have a site alteration and fill management plan. And this is a document prepared on behalf of an owner in accordance with this guidelines document that supports the bylaw, to demonstrate that the site conditions, the proposed methodology, the existing grade and approved grade meet the requirements of the bylaw, and there are mitigation measures put in place during the site alteration. This could be anything from setting up silt fencing, managing drainage, managing the topography, all these things that must be managed when you're doing a large site alteration. The permit requirements and fees are directly proportional to the size of the site alteration. So if you're just doing a 3 or 4 truckload situation, your permit requirements and the fees would be in proportion to that. If you're planning to bring in 1,000 truckloads of fill and really altering a large property, including drainage, and have the potential to impact your neighbors, then the amount of application due diligence that you must do and the fees that are associated with that are in proportion. Triaxle dump truck contains approximately 10 cubic meters of soil. So when we're talking 100 cubic meters, we're talking 10 truckloads. If we're talking 1,000, we're talking 100 truckloads. So as we've described the different sizes of site alterations that are outlined in the bylaw, and this is a flow chart that will help applicants understand where they fall and what they must do. Mentioned previously, the guidelines document is where we put a lot of the information that helps applicants understand how the bylaw works, how to make an application. Oftentimes people come in, they just read the bylaw, see a lot of legalese, and it's quite overwhelming. The guideline provides real world language and descriptions on what it all means and how to go about making an application and determining what's needed ahead of time and how to go about doing it. So for a minor site alteration, if you're less than 200 cubic meters based on property size, you need certain things. For a small, you make a small site alteration application and submit that for review. And to get through that process, you have maybe some geotechnical drawings you must provide, some drainage drawings, what you're doing, why you're doing it, where your fill is coming from if you're importing fill, etc. It's not an onerous requirement. Once you get into the larger site alteration, temporary storage of fill and things like that, there's a lot more sophisticated documentation in the application required. For instance, if you're going to do anything with an agricultural field, peel, topsoil back, you may need a report from an agronomist. If you're in a wellhead protection zone and you're bringing in a lot of fill, perhaps you need some hydrogeology reports to demonstrate you're not going to impact the groundwater. If you're going to be using a lot of town roads, then perhaps you have to have a traffic management plan in order to demonstrate how you're going to bring your fill in and have your empty trucks leave without impacting your neighbors and avoiding rush hour and maybe school bus schedules and things like that. Anything unusual would be at the discretion of the director, whether he wants additional requirements, he or she wants additional requirements. Maybe hold a public meeting, a PIC like this, so the public can weigh in on a large site alteration that may be controversial and may impact a lot of neighbors or traffic or things like that. And depending on what the director sees in the sensitivity of the application, may need to go to council for council approval. Whenever an application is approved, it comes with a permit that has a period of time that the permit is approved for, the volumes and all the conditions that surround the permit and what must be followed. Bylaw will inspect and oversee the site alteration as it proceeds, and any violations would be subject to the penalties and fines that are set out in the bylaw. To make an application, you would fill out an application permit for the size of site alteration that you wish to do. And the documentation is sent to the town, to the engineering department. It would be reviewed. And when the director is satisfied, a permit will be issued, and it would include the various fees and deposits that are required. So in addition to this bylaw, there will be amendments to the fees and charges bylaw of the municipality to have fees and charges that align with this bylaw. Again, the larger the site alteration, the more sophisticated the work being done, the fees and charges would be aligned depending on the size. The guidelines document is supporting documentation that help applicants and users of this bylaw to understand how things work. It's much more wordy and much more detailed. To assist applicants and publics, the guideline manual has been created. It is referenced in the bylaw, but it is not a legal instrument. So the guidelines manual can be much more casual with its wording and not have to worry about being held legally to be picked apart on a legal basis. It's there as a guide to help people make applications and understand what is needed and what the terms and the portions of the bylaw are meant to be in common language. The guidelines manual, although it's referenced in the bylaw, is not a legal document, so the director can update it from time to time as the director sees fit to help users and change wording as things change in industry. It provides rationale and guidance for the assistance of users. Fees and charges. So the fees and charges bylaw has been updated and it's been posted on the King website to demonstrate the changes that align with this bylaw. Permit application fees. If you're making an application, there will be a fee requirement. For larger site alterations and site alterations where you're importing a lot of fill, there may be requirements for a cash deposit. That puts money in the bank so that the township can hire additional help to review the application, such as hiring a qualified person or a hydrogeologist or an agronomist if there's some peer review needed of the document submitted. There are security deposits as a condition of getting a permit, especially with importing fill and large site alterations. The security deposit is something that the town would hold and refund at the end of the project unless it is needed to take action. And then the town would draw on the security deposit to take action. This is a user pay model, and the design is to prevent the taxpayers in the municipality from being out of pocket to manage these things. There's a municipal service fees, and these are applied when you're importing fill. So importation of fill offers the greatest chance of a environmental impact, and it requires a more scrutiny and oversight. So there's a municipal service fee that applies to that. Fees and charges will rise in accordance with environmental risk. Priority 1 with this bylaw is environmental and natural heritage protection. Protect the groundwater, protect the soil, protect farms, protect topsoil, protect trees, and protect topography where the topography is a natural heritage. So in a case like we're looking at the screen, that if this is the rolling hills of the Oak Ridges moraine, maybe it is not of good, it's not a good plan to bulldoze all these features flat and destroy some of the heritage topography of the moraine. Enforcement and orders. This is the teeth of the bylaw. So these are some sections that have been copied from the bylaw and placed here. I won't read them out in the entirety, but the point is that the officers and the director have the ability to issue orders. They can require cease and desist, and they can take immediate action to mitigate and remediate impacts of an activity. So if the officer and if a bylaw officer or the director is satisfied that there has been some violation, then they can take direct and corrective action. So oversight of activities. One of the key things when conducting site alteration and movement of fill is that the municipality provides some oversight. They're not responsible for what happens and what people do, but they do have a role in oversight. So we have municipal bylaw officers and inspectors, including a qualified person. The term qualified person here is taken from OREG 15304 and OREG 40619, and that means they have to be an engineer or a geoscientist with specific expertise in contaminated sites and soil to be a qualified person. So this is a provincial regulation and a provincial definition. The Township of King retains peer review consultants such as myself that are qualified persons to assist town bylaw in evaluating and overseeing the site alteration activities. The permits allow unrestricted access to a reuse site at any time. So if there's a site alteration occurring, fill is being imported, it's unrestricted access. Unrestricted access to all reports and documents. such as soil flow software, where electronic tracking mechanisms are being used by a contractor to manage his software or manage his importation of fill. Random inspections of all aspects of the operation, and regular random audit sampling of soil, surface water, and groundwater, soil vapor, whatever needs to be done. So the township has the ability to oversee, test, and evaluate everything that's going on, especially with the importation of fill, and bring in the assistance of qualified person or other technical experts that the township may need to assist their bylaw officers. And all costs for this reuse site oversight is to the operator's account. And that's where they would draw from the cash deposit. Again, we're talking about larger site alterations. If you're just bringing in 5 truckloads to a small lot and doing some lot dressing and things like that, these kind of details would probably not required. But the bylaw officer still may drop by and keep an eye on things and make sure that all the work is being conducted in accordance with the bylaw. So the municipality's liability is limited through language in the permits. So again, the municipality is providing oversight, but it's not necessarily taking legal responsibility for the importation of bad quality fill. Should it be found, it's all up to the owner and at the owner's cost to address that issue. Town to compel out compliance. Should an owner or operator not fulfill the requirements of the township, not fulfill the conditions of a permit, not respond to an order, the town has the ability in this bylaw to enter onto the property and undertake the requirements of the permit or the order at the owner's expense. Now, the township is not going to undertake this kind of activity on a whimsical basis, but should they get in a position where they're stuck and they're not having good traction with an owner, this allows them to take that action. Penalties. Every person who is guilty of an offense under this bylaw may be subject to the following penalties, and this includes fines that can range quite wildly depending on the severity of the offense, and up to $50,000 in some cases, and for subsequent convictions up to $100,000. The fine schedules are set out in the Municipal Act, so they're not. These are what the Municipal Act allows the municipality to set for fines. They're dictated here in the bylaw so that the bylaw officers can demonstrate to people that are not in compliance what the possibilities may be. Random inspection and audit sampling. There's nothing like checking and having bylaw officers having the ability to go out and check and bring technical experts with them keeps the town and the public assured that the work being done complies with the bylaw. Cost recovery, we mentioned before that if the town undertakes actions, as it's allowed to do in the bylaw, the cost for these actions could go back to the owner. And the way the bylaw is written, the cost for these actions, including interest, could be applied to the tax roll in the same manner as municipal taxes. And exercise any one remedy shall not preclude the exercise of any other available remedy, which means that the town may take one type of action and then may take another, but because they take one doesn't mean that they're giving up on the opportunity to take another action. If the costs are applied to an owner's title under the tax on the tax roll, this gives the municipality a lot of leverage that other regulatory agencies, such as conservation authorities, don't have, in that the regulations surrounding chasing delinquents on back taxes are very strict. So once it's on the tax roll, the town has a lot of options to chase them and get this paid up to and including taking over the property. I'm not a lawyer, so I can't give you the exact details of how that happens, but this has been written in the bylaw with the assistance of prosecuting attorneys, so that should something go sideways, the language is here so that they can affect successful prosecution. We talked earlier about an appeal. There's an appeal section in the bylaw to allow someone to come back to the town and discuss the concerns and the orders and see if we can address it without getting into expensive litigation. The keys to the success: an effective bylaw supported by a rationale document that's posted on the King website. And the rationale document just describes why the bylaw is written the way it is. The bylaw is full of legalese, and it's been put together in a legal fashion. And in order to give the public and the municipal staff an understanding of why it's written the way it is, we have a rationale document. There's an application guideline or a guideline manual that will provide the requirements and the details for applicants when applying for a permit. A fees and charges schedule under the fees and charges bylaw to outline what kind of securities, what kind of application fees, and what kind of municipal fees are required for each situation. Also, knowledgeable bylaw officers, inspectors, and external peer review QPs to manage excess soil issues and such things as illegal dumping. So we work closely with bylaw officers and are brought in when they get into situations where they need specialized expertise, and work together with them to accomplish whatever is needed to make sure that the site alterations are occurring in accordance with the bylaw. As a final summary, the new bylaw aligns with changes to provincial regulations and policy, environmental protection. It has teeth to address illegal dumping, increased fines, and the ability to prosecute. It provides more clarity to applicants with the guidelines manual and the rationale, and is a user pay fee structure to reduce the cost to taxpayers. The next steps: this presentation will be posted on the King website. We're tentatively scheduling another PIC, a Public Information Center, in 2 weeks. If you have questions and comments, please email them to kingbylaw@rjburnside.com and tell us what you think, and we will take that into consideration. We are preparing a comments matrix where we will be listing all the comments without showing people's individual names, and then describing how this bylaw addresses those comments or how we've taken the comments into consideration. And that will be published on or posted on the website as well, so people can see that their questions have been answered. And based on the consultation with the public, based on ongoing consultation with legal counsel and other agencies and stakeholders, such as the conservation authorities, the draft bylaw and documents will be revised and updated, and those versions posted. All documents will be on the speaking.king.ca, the website, under the site alteration and bylaw review. So now I think we could open it up to some questions and comments, and we'll be taking notes. And as mentioned, this will be recorded, so hopefully we can respond to your questions and put them all in the matrix. Sarah, do you want to open up any questions?
Sure. We've got one that came in here in the chat function. They're asking, usually with a site alteration, the build of a retaining wall or structure is typically required. Would King Township consider including a restriction building height of these walls depending whether the site alteration is for residential, agriculture, commercial, etc. purposes? This is to restrict the impact to adjacent properties with regards to the size of the site alteration.
Good question. There is overlap between the site alteration bylaw and things like building permits. So sometimes building retaining walls require building permits. If the retaining wall is small and the amount of site alteration is small, as described under the size descriptions for minor, small, and large site alterations, you would need a permit if you were doing a lot of site alterations. However, if you're applying for a building permit for your retaining wall, the building department may or may not waive the requirement for also a site alteration permit. If the building department figures that they can handle all parts of the permit and they can ensure control, they'll do it under that. It's the same if you're building a house and you're doing some filling around the house and the driveway. That can all be done under a building permit, and in this case the bylaw would be waived if it's under a building permit. So certain size bylaw or certain size retaining walls require a building permit, so you'll be captured there. And then once you get to a certain size where the site alteration, the change of topography is of a certain volume, then you will require a permit under this bylaw to do that work. So unless it's really small, you'll be captured with this.
All right, we've got another question here. I'm going to unmute one of our guests so that they can speak. All right, go ahead.
Which guest is it, Sarah?
It's Jay, and I think it's Ange. Did you have a question?
I did. So I guess what my first question is from the perspective of somebody that is impacted by a large scale issue that's been ongoing and have dealt with bylaw. My first question, I guess, and the biggest question is consequences for not following the rules. Is there a consequence for the person doing it that's not following the rules to have to remove the soil until approvals are given? Because it seems like it's, in a lot of cases, it's more of begging for forgiveness rather than asking for permission. I'm impacted greatly by a significant one, and I don't see any difference, and it's been going on now for about 8 months.
That is a good question. There is, in many municipalities, there has been a problem of legacy, and the bylaws have been poor or poorly enforced, and a lot of people have just been ignoring them. And two things: one, OREG 40619 really starts to put provincial level control on the movement of excess soil. So if that's happening illegally, there's provincial ramifications. On the municipal, at the municipal level, this new bylaw has sufficient teeth in it. If you're caught importing fill, doing site alterations without a permit, the bylaw officer has the ability to charge you right away and issue fines and force you to, and issue orders compelling you to either remove the material, restore the site alteration you've done, or get in line with a permit, whatever the bylaw officer and the director feel is sufficient action to take. If you fail and you keep doing what you're doing, you saw the fine levels, they start to get really painful. And most of the people doing this kind of work, they're going to feel it in their pocketbook. So the ability to fine and prosecute and even have the town take over the situation and rectify it, such as removing imported fill that is not suitable and shouldn't be there, then the new bylaw should be able to accomplish that.
So how do we, as homeowners who are close by this and are affected by it, ensure, or I guess keep up to the status of what's going on with respect to the township's involvement bylaw-wise? And I may as well just ask the other part of that, and that is, how do we avoid bringing in fill strictly for a money-making endeavor with large-scale properties when you're being paid X per load and you're bringing in excess of 1,000 loads already? How do we follow up on what the bylaw status is as far as fines, or whether it's going to be rectified, whether it has been rectified?
Yeah, that's certainly a king administrative situation. The bylaw has all this teeth and has all this mechanism. Um, Things like permits would be publicly accessible to review that a certain property has a permit, and this is what the permit permits. So if you have a permit on a property and it allows them 100 loads, and you've seen 5 loads go in, you could check with King and see that that property is permitted for, say, 100 loads, and you go, oh, okay, 95 to go. If you've seen 200 go, then you know, wow, they're way over the permit. I'm calling bylaw and getting them out here and getting some action. So your question is, how do you find out whether sufficient action is being taken and whether bylaw is on top of it? My suggestion is talk directly to bylaw and make sure that they know, and they should be able to tell you, it should be public information, what actions they're taking. And certainly if they issue an order, the order would be public, and it should be on the King website.
All right, we've got another question from Tony. And so, Tony, I'm going to unmute you here so that you can ask your question. All right, Tony, you should be okay to ask your question. Are you able to ask your question in the chat, Tony? I'm not sure. It doesn't look like you've unmuted here.
Maybe leave Tony open and go on to the next person and he can jump in.
All right, we had a question pop up in our chat as well. So we had a comment about Regulation 406 requiring the imported material to be deemed beneficial revenues, thereby taking away the option of accepting money simply for the money. So that came in from Leah, and we had a question from Debbie. Slide 24 shows rolling hills, and you said that it was the natural heritage of the ORM and should not be flattened. What if this land where a farmer was trying to grow grains or corn and says that it would be better if it was flattened? You've said that the farmers have their rights too. How would their application be assessed?
That's a really good question. And if a farmer is importing fill to fill valleys or do site alteration in order to improve their farmland, that's under the right to farm and would not apply. But it's always best to check with the municipality and see that if it does. So that's a common question. And in most cases, the farmer must demonstrate that what they're planning to do has good value, and from a may have to hire a consultant like an agronomist to demonstrate that what they're planning to do makes good sense for the preservation of the soil, improvement of the soil, and management of their farm. So it's not the purpose of King to stop farmers from managing their farms, but it certainly is to not damage farmland, not damage soil, and not damage the heritage topography. So I'm being a little on both sides of the fence with this description. The point is, if you're going to be importing soil for no other purpose than to make money and pile it on farmland, that's not going to fly. If a farmer wants to do some regrading or has a valley right behind their house and they want a little more paddock land, that's something that is going to be perfectly acceptable. So there's a balancing act between real world need and what makes sense, and being able to demonstrate that with some technical reports. from appropriately qualified people in soils versus the effort to just stop this dumping on farmland. Earlier, somebody mentioned, how do we stop people that are just importing fill for the sake of making money? Exactly. If you don't have a compelling reason to do the site alteration, changing your grades, and upgrading your property for some purpose, then chances are you're not going to get that permission because it won't fall into the approval levels for a site alteration.
We've got Cleve responding just in terms to that comment. Oh, where did that go? Just bear with me here.
A lot of people have seen over the years the importation of fill to the Tottenham Airport on Highway 9, Scugog Airport, and a number of other sites where people have managed to import large quantities of fill. It gets a lot of news in the newspaper. Sometimes people rent farmland, and when it's an absentee owner, the tenant actually starts bringing in fill and pocketing the money and then abandoning the property. So I've seen all of this in a lot of places, and the municipality depends on people calling in when they see something that looks untowards, and bylaw responding to that. And then, as described in this bylaw, once they see something that's in violation, if there's no permit and you have to have a permit, then you're automatically, open to orders and charges as outlined in this bylaw. If you have a permit, then, and it's been approved by the municipality, then bylaw just makes sure that you're doing everything you should be doing in accordance to the conditions of the permit. And if you're not, then you can be fined and shut down. The purpose of posting a security deposit also means the town has the financial wherewithal to hire security 24/7 to blockade your property. Should you be suddenly importing all kinds of fill and you can't, and the township's having trouble stopping those trucks and shutting it down, with the security deposit, if somebody has a permit, they can do that. If somebody doesn't have a permit and they're doing this without a permit, they still have the ability of taking money out of their town's pocket, doing that, and then recovering it later from the owner by putting it on their tax roll. So that protects the residents of the town from the burden of the cost, and has the teeth to make sure that this is stopped physically by having security at the site 24/7, and then the value of the property on the line through putting fines and penalties on the property brings the owner to the table. Most properties in King are worth a lot of money, and once you start hitting people in the value of their property, they tend to start becoming a lot more easy to deal with.
All right, and I'm going to open up the floor to Sandy. She had her hand up. So Sandy, I'm just going to unmute you here so that you can ask your question. You might have to unmute on your end as well.
Can you hear me?
We can.
Oh, very good. I've had a problem with Bylaw and King Township dealing with a neighboring property of mine for about a decade. They don't have the zoning for the fill and the rock, the thousands of truckloads. So I don't think this is retroactive, but what will be happening going forward then?
Once the bylaw has been approved by council, it is in effect, and then anything from that day on, unless there is a grandfathered approval already, like if the town had made agreement with that owner 10 years ago to do something, that's a legal agreement and can't be altered. And again, I'm not a lawyer, but with the case of
there's no agreement because there's certainly been no conversation with any of the neighbors.
okay. Well, this bylaw will give them the teeth day one to take whatever action is needed if there's no permanent place, no agreement, and anything that they're doing, if they're out of If they're in violation of this bylaw, then bylaw can take action and this can be enforced.
What date?
So what date would that be? I'm sorry, just to refresh.
No problem. We expect to finish all the public consultation and update revise the documents based on public input over the next few weeks by the end of the month. And once that's done, legal counsel will do a last run through of the documents to make sure everything's okay. And then it would go to council for approval or consideration.
Okay. Thank you. I'm just confused that the property I'm referring to on Highway 27 doesn't even have the correct zoning. So I don't know why this has never been addressed by King. They're
That's a
well
good
aware of
question.
it. It is a good question. It's a good legal question.
Well,
thank you.
The idea with this bylaw, as we've laid out, is to make it very clear what's allowed, what's not allowed, and what you have to do to get a permit. And if you don't have a permit, then the teeth are here. And if you do have a permit, you must follow the conditions of the permit. So hopefully this will get people in line. And there's nothing like a few fines and the word spreading to start getting people to stop doing well, I didn't know, and come into the town and do things right.
Well, I guess the other thing in your presentation is it talked about discretion by bylaw. Is that going to continue? Because we face that all the time, at their discretion.
Yeah, and it is up to bylaw discretion. However, I would think that, and I would just speak for King, if the bylaw is very clear on what is allowed and what is not allowed, there may be ramifications for the municipality if they're not enforcing things that they state, should be enforced. The discretion was more on the basis of minor things. A couple of townhouse neighbors squabbling over something, rather than hundreds of trucks going into the site. That doesn't sound that doesn't sound very discretionary to me in something like that.
No, it sounds very obstructionist, doesn't it?
And the question with excess fill, with OREG 406-19 coming into effect on January 1st of this year, means that there's provincial regulations that they need to be following, in that the soil that they're placing on the site must meet the quality suitable for that site. And if it is not, then they're out of compliance with ministry regulations and open to all the types of ministry prosecutions and fines and orders that are available.
Yeah, that's like the whole transfer station thing. Yeah, okay. Cool. Thank you. That's terrific.
All right, well, thank you, Sandy. I'm going to move on to Brian's question. He was wondering what coordination mechanisms have been considered for permitting and enforcement with conservation authorities within the bylaw?
Really good question. King has been in dialogue with the Conservation Authority for quite a while on this, trying to see where they could each take responsibility so it wouldn't be a dual responsibility. There were changes to the Municipal Act a few years ago, which changed the ability of the municipality to waive its authority in Conservation Authority lands. That no longer exists. So that means even in Conservation Authority regulated lands, the municipality still has jurisdiction. So in those lands, you have two jurisdictions: the Conservation Authority and the municipality. This makes it really hard for applicants because they have to get two approvals in order to do anything in those lands. And there's been discussions of how one of the two bodies, the Conservation Authority or the municipality, will take the lead. Until that's really resolved, right now it is you must satisfy both bodies and both sets of regulations. And the municipality, because of the way the legislation is written, has a little more teeth than the Conservation Authority, especially with things like putting costs on a tax roll. And so it's often the Conservation Authority comes to the municipality for assistance in controlling and regulating illegal activities within regulated lands. So I'm working on a couple of situations now where the municipality and the Conservation Authority are teaming up on and sharing costs on prosecution of illegal dumping. So we expect to see that kind of cooperation moving forward to continue.
All right, and we've got a question from VJ from Schaefer's, and he's wondering if this minor site alteration tool can be used for residents to get approval prior to filling in drainage swales so that adjoining properties are not impacted. Often developers cannot get final approvals pending those issues.
Yeah, that's, somebody's been working with civil design and municipal approvals on subdivisions. It is a problem. So the bylaw, this bylaw has in it the condition, the requirements, whether or not you have a permit or whether or not you need a permit if you're under the small thresholds. So little changes to swales and backyards of new subdivisions wouldn't require a permit because they would be such small volume changes. However, the bylaw does stipulate that even if you don't need a permit, you can't alter the environment. You can't damage the environment. You can't cause an adverse effect. You can't alter drainage that's going to affect your neighbor. You can't alter low impact development infiltration features. So the bylaw would have the authority to compel people not to fill in these drainage swales and not alter the drainage when the site plan is designed to have all these swales in place. If you fill them in and you alter them, you're in contravention of this bylaw. So this bylaw could apply. So for the answer to the developers that are having problems with people changing things before the subdivision is fully complete and then provided to the town does have the ability to go in even when the subdivision has not been fully complete and signed off for the town and issue orders to these people that are filling in these swales and doing these alterations.
All right, and I just wanted to loop back to Debbie. She had originally asked about the natural heritage of the ORM and whether or not it and should not be flattened. So she had made that comment, and she was just following up on the response that that was given. Isn't a possible response to a permit application is that the land topography is what it is? Perhaps the farmer needs to think of working in another manner and perhaps should not have bought the land. So I just want to give you an opportunity to respond to that, Jim.
Yes, absolutely. Massive changes to heritage topography or massive changes to lands, farmlands or otherwise, the answer can be no, absolutely. A landowner does not have the right to affect the greater environment. Strip their land down, affect the groundwater table, and impact neighbors, and damage heritage topography. So, if there isn't a compelling reason, and if the applicant's proposal does not fit in with the the Oak Ridges moraine legislation and what is seen as good environmental stewardship, then by all means the director can turn it down or suggest amendments or alterations that would fit with the town's mandate to protect those things. So the answer is yes, the control is there. And if the person goes ahead and does it without approval, then the teeth in the bylaw allow action. And this is not to impact the right of farmers to control their topsoil and manage their internal drainage and their normal farm practices. It's when it's not quote unquote normal farm practices. And sometimes that may take a ruling of the of the Normal Farm Practices Board to decide whether it's normal or not. King will make its determination, and then the farmer is well within its rights to take that to the board and get their decision. But so far, our experience has been that the Farm Practices Board has turned its thumbs down on applications to just import massive amount of fill onto a farm valley just to fill it up and make it flat. They have not seen that to be normal farm practice.
And VJ, who had asked about the filling in of drainage soils, just wanted to confirm that the answer was yes to this question. Okay.
The bylaw has the ability to do that.
Perfect. Okay. And we've got one more question that's come in regarding what the official, it says clarification on land heritage.
I'm not sure.
I think maybe classification on land heritage, like how we would define it, or sorry, heritage land.
If it's in Oak Ridges Moraine, then the Oak Ridges Moraine Conservatory Act and the various documents, and I may be using the wrong wording here, but they define what is heritage lands in that type of legislation. In other cases, lands or features are defined in some other documentations, either within the township has something of their own, and the town would apply those in making any determinations on heritage. That would include things like archaeological. If there's an area where there's concerns of First Nation archaeology or something like that, people applying for a massive site alteration would have to provide an archaeological report. And if there is something of issue, they would have to, follow the mitigation requirements under the regulations that deal with that type of archaeology.
All right, and I'm gonna pass the floor over to Tony. You're unmuted on my end, so hopefully your sound's working for you.
Is that a Tony Veronese?
It is.
I see it's unmuted, but I don't
think we're getting any audio for you, Tony, but you're more than welcome to type in a question, and certainly if you get your audio to work, just let us know.
So just leave his microphone on maybe, and you can chime in whenever he gets a chance.
Yeah, I'll leave it unmuted.
Anybody that has any questions, as discussed earlier, we can always just email them to king.bylaw@rjburnside.com on behalf of King, and we'll make sure that they get included in the matrix of comments, and we'll make sure that we respond to each question or comment that's provided to us.
Absolutely. We've got two more hands that have gone up, so I'm going to open up the floor to Jack next. So just give me one moment here and I will unmute you.
I see Jack is muted.
So I've unmuted him. Jack might have to unmute himself on his end to speak.
Jack's still muted. I'll just leave it open, and
yep, I'll leave it open, and
Jack can chime in when he's.
I'll move on to Carolyn next here.
Okay. I see it muted at my end.
So again, I've unmuted it, but I believe that users will have to unmute on their side so that it's intentional that folks can hear them.
That's Carolyn Alley
Mhm.
from King. So
Tony was wondering if he can phone in his question. Absolutely. I'm not sure if we've provided a contact.
we didn't
phone
provide
number.
a phone in on this one.
Okay.
So some people are saying they can't access their mute buttons.
Let me try here. I'm going to allow attendees to unmute themselves just for a moment here.
Okay.
So that
All right.
that we've opened up some more control there. So I believe by default people will stay muted. I don't.
Oh, sorry, it's Carolyn, and that worked for me.
Oh, perfect.
All
Okay,
right.
maybe that's the trick here.
So I just and I thought we were wrapping up, so I kind of raised my hand, but I'll go now. I just wanted to here. I'll put on my camera. So I just wanted to highlight that that the site normally, in order to construct a pool, we've been using our current site alteration bylaw to issue a permit to construct the pool, and then the applicant would also need to get a fence enclosure permit from the building department. So with this new bylaw exempting that small amount that would be the construction of a pool, when we go back to council with this bylaw, we'll also be asking to make a minor amendment to the fence bylaw, which includes the fence enclosure permit to kind of incorporate the review that we would normally do under the site alteration when you're constructing a pool. So, drainage, that kind of stuff. So just wanted to kind of highlight that when if you dig into the bylaw and realize that pools would be exempt under this, that we are going to catch it in the fence enclosure permit, which is aligned with how other municipalities are doing it. So just wanted to kind of highlight that so folks would know when the report comes back kind of why that's in there, and yeah.
Thanks, Carolyn.
All right, and I know Tony was still having some trouble with your audio. Did you want to try and unmute yourself now, Tony? I wonder if that'll work on your end now.
Or Jack, can you get your microphone unmuted? There, I think you did. Nope, maybe you didn't. There you did.
Yeah.
Hey, Jack.
Hi. Jim, I had a question kind of at the macro level geared to the legislation that's coming through the province. You had mentioned the other day when we spoke about there being up to 25 million cubic meters of earth to go someplace around the GTA each year.
Yep.
Does the province
I see Jack. His face is frozen now, so I suspect he's got an internet glitch. We'll let Jack get himself unfrozen. Sarah, is there anybody else on the line?
Let's see here. I think Tony's the last person with an outstanding question. And we didn't have a call-in number for the meeting to forward, but maybe that's something that we can ask, or Tony can get in touch with us after. Oh, I think he's readmitting himself here, so hopefully maybe that'll fix some of the sound issues. All right, Tony, Are you back? Are you back online and able to try your audio?
Well, we're waiting for a few people. I guess I just addressed the one of the motivations for this bylaw has been the battle in a lot of municipalities over illegal dumping or legal dumping of huge quantities that could cause an environmental impact or is just out of control. And there's a lot of neighbor concern, such as the Scugog Airport, where they took in thousands and thousands of tens of thousands of truckloads and under the guise of improving an airport, and the soil quality was questionable, and now it's just sitting there in some sort of limbo, and nobody wants to see that happen. So with a bylaw like this, you have an application process that should catch questionable applications and questionable purposes of conducting a site alteration right up front and comb them out. And if an applicant is approved, it has a lot of conditions and controls in place to make sure that what is being applied for makes environmental sense and is controlled and does not get out of hand. Problems in the past in some municipality has been where they've issued an approval for 1,000 trucks, and after 5,000 trucks, somebody finally notices and starts to do something about that. There's a lot more controls in these places, and that includes that permits have to be renewed after 1 year, or they could be even set for after 6 months or 4 months that requires the applicant to come back to the township. And the holding of security and a cash deposit means that the applicant and the owner have vested interest in making sure they don't risk that money by doing things that are in violation of their permits, because they know that whatever action is taken is going to be taken out of the money they've already put up. So that should address a lot of the out of control situations where a permit has been issued, but it gets out of control, and where a permit hasn't been issued, and they should have a permit, and there's a lot of illegal filling going on all over the place. The new provincial regulations will help stem some of that, but this new bylaw will give the bylaw officers and the municipality's legal counsel the teeth to really make these violators feel the pain quickly and effectively and get it to stop. Nobody wants long drawn out legal battles, but if through the use of fines and the ability to put the costs onto the tax roll are mechanisms where they can feel the pain very quickly and hopefully compel action to stop whatever they're doing and begin the steps to rectify.
All right, we've got a follow-up from Sandy that I wonder if maybe you can expand on, Jim, or help provide some clarity to, just around not understanding that the township has the power to enforce bylaws, but chooses not to.
The discretionary part of it.
Yeah.
That opens the town up to liability if they're using their discretion to avoid environmental stewardship or environmental protection. I'm not a lawyer. I can't speak about the law, but I don't think this municipality, from the input I've gotten from staff and the input from mayor and council, I don't think they have any interest, and the policies of the municipality have all been directed towards environmental stewardship and protection of the environment. I don't think there's any thought that they would avoid taking action where the environment is in jeopardy or where people are doing things that could negatively impact the municipality and the and the natural environment. So I'm quite confident that when situations come up that are of significant concern, the municipality will react. The discretion I expect would be used in small neighbor to neighbor arguments about flower beds and things like that. It seems a little bit much to invoke this type of bylaw to get in the middle of who's planting too close to their petunias, too close to a fence line or something like that.
All right, we had an additional question. Why are landowners who bring in fill without the appropriate permits not made to remove it at their cost in addition to the fines until their permits are in place?
This bylaw allows exactly that. If you don't have a permit and you've done something without a permit, obviously the first thing the municipality will do is to try and get you into compliance as quickly and as effectively as possible. People always say, oh, I didn't know. Okay, well, now you know. Here's the permit process. You must stop and cease all work and then follow these requirements to get into compliance with a permit. And if they cannot get in compliance, and the compliance would include demonstrating that whatever material they've brought in will be acceptable under their permit at the end of the day. But if the quality of material they brought in, the amount of material they brought in, or the location of material that they brought in will not be permittable at the end of the day, then it has to be removed, and an order would be issued that it be removed. So there's no intention to allow anything to stay that wouldn't be normally permitted. And it would be up to the town's discretion to whether they would leave something that was brought in without a permit to stay after they get a permit, because it would be permittable under the permit. But the town is well within its rights to issue a stop work order and issue an order for complete restoration and to any site alteration and the removal of any fill that was brought in illegally. Because without a permit, if you've brought it in illegally, it is illegal, and the town can take the actions to rectify that illegal action.
All right, I believe Carolyn had another question, so I'm going to pass the floor over to you. You should be able to unmute yourself, Carolyn.
Yep. I just wanted to, I've seen the conversations in the chat, and I think we're really moving away from what the purpose of this PIC is about. This is about, getting a public input on the proposed changes. And as I said, I think we're getting away from that. So I just, I'd like us to kind of focus back on to, what is the purpose of the PIC, and ask Jim questions on what, what's in the proposed new document. So I guess I'll just ask are there any more questions or comments on the material that was presented today? So I hear none, see none. So anyway, so Jim, I'll certainly let you conclude and say I think in your thank you and next steps there was based on if this meeting, if we were going to go longer than the 2 hours, we thought that perhaps there'd be a need to schedule a second meeting. I guess kind of based on what I've heard today, I think we've we still have another half an hour, and so it sounds like we've addressed all the comments that have been before us today. And as Jim mentioned, that this presentation is being recorded and will be posted to the speaking site. So I guess my recommendation is I don't think we need a second PIC, but I guess if there's any comment from yourself, Jim, or the audience, we could kind of make that decision at this meeting if we feel there's a need for a second one.
Yeah, we'll wait and see what we get as far as emails and requests over the next few days, and base it on that.
Okay. It does look like Tony's made a request for a second meeting, but I understand we haven't really been able to connect with Tony. So, I'm sure there'll be some follow up after the meeting with you, Tony, to make sure that we're able to answer some of your questions.
Well, and I'm wondering if Tony, do you just want to call my cell and I can put my phone up to my microphone and then you can be heard? I kind of reached out in the chat to see if you wanted to do that. So, perfect. Okay, so I'm going to send you my number here, which I guess everyone will have. So, yeah. Okay, so Tony, if you just want to give me a call, I will hold my phone up to the microphone and we can get you looped in and join the conversation. There he is. Tony.
Thank you. I really appreciate you giving me your phone number so that I can be part of this.
No, absolutely. So I have you on speakerphone, and I'm not sure if you're getting any feedback, but I think, I guess, Jim, can you hear Tony then through my phone?
I can.
Okay.
Perfect.
You're up, Tony. Long awaited,
yes,
but you're here.
And I apologize about the technical
No
difficulties.
worries. No worries.
Although I do agree that we need some sort of site alteration bylaw, I'm not sure how different it is than what we have right now and what tools the township has. I am extremely concerned about the amount of fill that could be added in the hamlet in the older parts of the township. As you know, that a lot of these places rely just on the topography of the properties for drainage. If people are putting in 20 yards or 20 truckloads of fill on a half an acre of property, that is a humongous amount of fill that's being added. That in itself will change the topography of the properties. And I think that we're asking a lot of the bylaw department in order to police, when it should be people who are requesting the permit that should be policing themselves. Maybe they should get a topographical survey done before and after to ensure that they are in compliance or that they're still maintaining the swales or the drainage. So I have a real concern about even the minor alterations and the impact that it could have on the small communities or on the older parts of the township. And I do understand the other people's frustrations about bylaw is that the bylaw will only react, the bylaw officers will only react when they receive a complaint. Unless that has changed, I'm not sure how effective the bylaw officers could be. Has the township hired more bylaw officers to enforce this?
Okay, maybe I can start answering some parts of that. With respect to the importation of fill on the small properties, there was a formula in the minor site alteration that would mean that.
I went through that formula, and that's a heck of a lot of dirt.
Well, it depends on your property size. So if you have a small property and you're only allowed a half a truckload or something like that, you really can't do all that much.
Property is 1,700 square feet, 17,000 square feet, which is just under, let's say it's a third of an acre. So according to the formula, how much fill can I put in?
I'd have to go back and check, but you'd probably be down.
Well, it depends. It's a heck of a lot of fill.
Well, the maximum is 20 truckloads.
Is that all of that fill is going to probably upset my neighbors?
You're still required under this bylaw, regardless of whether or not you need a permit, to not cause an environmental impact, not affect drainage, not affect your neighbors. So whether or not you need a permit, that's still in place.
And many of the people I'm sure on this call have been faced in situations where people have taken on some alterations. It's affected the neighbors, or the neighbors complain, and then it becomes a civil matter, which the township doesn't get involved in.
So do you have any suggestions on how we should alter or amend this bylaw to address that concern?
I think that we're just allowing people to put too much soil in. To really, the only time that people should be filling in is that if they're top dressing, which is maybe 20 yards, which is a truckload, maybe.
So you would like to see the thresholds for requiring a permit lowered from what they are now,
Yes,
and be
yeah.
less. Okay, so that's something you would
and
like
I
to see
think
changed.
that, lowering the threshold of the amount of soil that could be dumped without a permit, it would be great. We also have to remember that a lot of people now do not want to spend the money of having their soil hauled away. So when they're doing when they're redeveloping or renovating their house, they'll often just spread that soil in order to avoid those $800 trucking fees.
Right. So the answer to both those cases is lower the threshold of where you would need a permit and town involvement.
Yes. Yeah.
Okay. All right. We will revisit
I know
our
that
volume
when
count.
it's small and major site alteration is that there should be an engineer involved that is on top of that. And we'll be monitoring what's coming in and what's coming out. Because ultimately the engineer would be responsible if there is an issue that arises later. So our focus, or my focus, also that there isn't a stormwater management plan yet out, is that we have to minimize the amount of fill that people could be adding in residential areas, which is pretty much covered in that small minor alteration proposal.
Right. So you would like to see the minor amount that's required without a permit lowered so it's much tighter, and you need a permit. The permit threshold is lower so that people need a permit for even smaller application or smaller site alteration.
Absolutely. Yes.
Okay, we'll revisit that. There was a lot of input put into that threshold number. It's always controversial. Some municipalities want to set it at nothing.
Based on the fact that we don't have any stormwater management systems here, there's really no systems. So anything that is added onto our properties is going to ultimately affect the person behind me, the person next to me. It's going to affect somebody.
Okay, we'll revisit the threshold level for not requiring a permit, the minor site alteration threshold level formula.
And one more question, because a lot of this is being put on the bylaw department. Has the bylaw department's philosophy, has it changed that because typically they would not accept complaints from people, or they would not investigate issues on their own unless there was a complaint put forward?
Sorry, that's getting off the topic that I could answer.
Okay, how about Carol? How about Miss Cronsberry?
Well, it's Carolyn, and
Carolyn. Okay, sorry.
That's okay. So I've got the mic and the phone, so I'll just jump in.
I really appreciate you going to this extent in order to include me in this. I really appreciate it.
Absolutely, no. Okay, so So site alteration, issuing the permit is done under engineering, which is under my group. And so to your point is that, you know, we're the engineering department, so we have our engineering hat on, and you know, grading, elevations, everything you spoke to is what we're going to be looking for in the permits, right? So
Yes.
we, you know, it's our due diligence, it's our job. You know, we have Jim as a resource if we need him,
Yes.
but typically, you know, survey before, definitely. You know, in some cases we've done surveys afterwards to confirm, you know, depending on how many
Yes.
truckloads we approve,
Yeah.
right? So
Yeah.
it's a case by case basis, but recognizing that, you know, I spend a lot of my day on drainage, right?
Yes,
so we
I
like
know
to
you have.
so we
Yes.
like to be proactive than reactive.
Yeah,
So,
and that's what I'm asking is for us to be proactive,
Yeah.
because we don't have the stormwater management plan in, and any work that's done on TRCA property, you have to provide with a topographical survey.
Yeah.
You have to.
Yeah. So
Before and after.
So to your point, right, we're evaluating each application. The bigger ones will have way more requirements in terms of, you know, stuff they have to submit versus the little ones. Now, in terms of enforcement, so you know, when a call comes in, then my understanding is, you know, a lot of times, you know, engineering and bylaw are going out, right, to determine,
Yes.
you know, is it a site alteration issue? You know, do we have a permit? Are they in violation of the permit? And I'll just mention on Nancy's behalf here, and I'm not sure if she wants to jump in, but you know, King Township is a large area, right?
Absolutely.
And so you know, a lot of our bylaw stuff is done by complaint, right? Because we can't be everywhere all the time, right?
100%.
But what I will say is you know, I've worked in another municipality where we lived the site alteration issue when they were digging out the tunnel years ago in Toronto, and you know, our engineering staff were, every time we saw a truck drive down the street, we'd be like, where is it going, right? So when we start to have these kind of issues, you know, eyes wide open, and but we can't be everywhere all the time, so we really we really rely on our community to provide those complaints.
I get that, but we're also putting a lot under this site alteration plan or proposal, is that we are putting a lot on the bylaw department to enforce when they are overwhelmed with everything else that's going on.
And so, so if a permit is issued, then all of the inspections then are paid for by the, you know, so it depends on the application, right? So if it's a really big one, then, you know, we do have the ability to, you know, hire a third party company to do, you know, more inspections if we don't have the resources to do it. So I think the point that Jim made earlier is that, you know, this is a, you know, when you come in for a permit, this is to be a no cost issue to the community, right?
Yeah.
So as I, you know, as a manager of development, you know, development pays for development, right? So site alteration will pay for site alteration. So again, you know, we're here to absolutely solicit comments and in order to provide a, you know, a good, like, you know, a site alteration bylaw that has you know, community support. The one thing I just wanted to address on the minor site alteration on the so I have the calculation up, and you know, again, you know, we have our speaking site, and maybe we can run some examples, you know, to kind of show that. But I did a quick one. So if you have a third of a hectare site, or do you have a third of an acre? Yeah. So it's a 1 hectare property would be allowed 20 trucks. Right?
That's
so it's hectares, not acres.
If you calculate 20 trucks times, so that is 20 trucks, that's 400 yards, if I'm not mistaken.
So it'd be 200. So, and again, I think that what we'll take back as an action item is to, you know, provide some you know, some calculations of what that looks like, right? So if you have a 1 hectare property, but it also, you have to minus out the buildings, right? So again,
Yes,
so I think
and that's the whole point, is that my property is 17,000 square feet with the house. So if you spread 20 truck loads around my property, my neighbors are going to be in big trouble.
Yeah, but I think what we're saying is you don't have a hectare property, so
No,
therefore
so
you don't
it'd
get.
be a third of that, correct?
Well, and so we'll do the math, because acres to hectares, right? So
Yes.
it's so anyways, but I think what we're
all as I'm saying, Caroline, is that, you know, in lieu of everything that's gone on in the older parts of the township, areas that are susceptible to flooding, I think that we need to proceed with this site alteration bylaw. We need to proceed with it with caution, and especially in areas that are susceptible to high groundwater, etc. Because any more dirt coming in is just going to compound the situation.
And so 1, 2 times 2.
All right.
And again, we'll run I think some scenarios to put it in perspective for people, right? Okay. So then we can better assess, you know, does the formula maybe need to be, you know, adjusted to what seems appropriate, right? But I guess what we're trying not to do is regulate every spoonful of dirt either, because we just don't have the resources for that, and that's onerous too, right? Like for somebody. So anyway,
but I would rather that we go on the side of caution than the free for all that it's been for quite some time, and then you have neighbors that have been complaining for 10 years about the fill that the neighbors put in. So I think that it is time that we do look at this. We do, you know, look at the needs of the large properties as well as the small properties. But we just need to proceed with it and not assume that bylaw is going to be the police of everything, because I'm sure that under present bylaws is that there's been very little charges, if anything, laid regarding to excess fill.
Okay, super good.
Okay.
Yeah,
right.
super
We
good
appreciate your comments.
Yeah.
Okay, thank you.
Is there anything else, Tony, that you wanted to?
No, I really appreciate it that you went to this length to include me in the meeting. So I appreciate it, and I thank you very much.
Our pleasure, Tony.
Thank you.
Okay, Jim, back to you. I'm turning off my mic, and Tony, I'm gonna hang up. Is that okay?
Okay, absolutely.
All right. We did have one last question that came in from Jay, and I think maybe that's going to be our last one for today, just because we've sort of gone close to an hour past what we were expecting to do. So I'm going to pass the floor over to you, Jay, and then I think we'll be ready to wrap it up.
I am here. Can you hear me?
We can.
Yep.
Great. I'm wondering why a permit would ever be issued for a large property, farmland, in excess of 150 acres, ever be given a permit to bring in fill to alter probably a third to a half of that property, when obviously there's 150 plus acres to be moved around if at all needed, rather than in my case, I'm guessing probably 1,500 to 2,000 loads so far that have been brought in over the last 8 months, for simple, what was apparently a drainage issue, which I can assure was never a drainage issue. Why would they ever be given a permit really to bring in that kind of fill, or any fill, if they have 150 acres in which to move around to fix the problem?
Well, that's a specific site, a specific problem, and from what you're saying, it sounds like they got permission to do it. So I'm not clear.
No, they did not.
Oh, they did not get permission.
No, they were shut down. But the reality is they've got 150 acres to move dirt from, and it's now become a moneymaker for them.
Sarah, can you let Carolyn Ali answer this?
I sure can.
Actually, now we can control our own destiny. So
Yes.
anyways, yeah. So I think this really isn't the forum. I think if you want to have a separate conversation with, myself or Nancy or someone at the town, I think, on a specific site, we can definitely, let's take this offline.
Well, there's a general comment about
Okay.
why would they ever be allowed a permit to bring in fill when anybody has more than enough that they can move around of their own if so need be.
Yeah.
It's all an engineering, it's all a submission and application. The process allows anybody to make an application for anything they want, and then it is up to the review process to determine whether or not it meets all the requirements of the town. The township has requirements for, protection of the environment, protection of groundwater, protection of topography, and all these other things. And if it all makes sense and you're not damaging farmland and you have an an agrologist report and everything is fine, then you would be given a permit. If things are not fine, you wouldn't be given a permit until the application meets all the requirements. So I can't say why a particular one got it and one didn't get it. We'd have to look at it on a case by case basis, but anybody can make an application, and as long as you meet all the requirements, then it's fine. But such things as you describe as filling in a bunch of farmland doesn't sound like something. Doesn't sound like it without a compelling reason. But if you're building a subdivision and you're under a subdivision approval, that's a different story. So,
well, the virgin farmland in King obviously is quite good in most cases. And I don't see the need in bringing in outside fill into a township where we have more than enough of our own and specific properties have more than enough of their own. It just, to me, you're opening up an opportunity for things to go wrong, then that isn't needed.
And the application process will vet those requests. And if they don't make sense, then of course it will be denied, or the volume will be that's possible will be reduced, or whatever, based on the merits of everything's based on the merits of the application. And we don't want to deny people the right to apply, but the guidelines manual will give an indication to people of what may be possible and what may not be possible.
Okay.
Okay, Sarah, is that it?
I believe so.
All right, then we'll close it up. Really appreciate everybody's contributions today. And as we mentioned before, this will all be posted, and we'll be providing a written response to each of the questions that were asked, and the items that were brought up. We'll provide a little explanation for them as well, and we'll go from there. Thank you again.